joining us for the second session today as well. We will be starting now, and and do we wait another couple of minutes? Okay, okay. We might as well just go ahead and start. And to those of us joining us online as well, we do know that we've gotten a couple of questions through the chat online. And unfortunately, during the previous session, we didn't have much time to address that due to time constraints. But at the end of the second session, we will have time for a short discussion, a Q&A session with the audience. So please feel free to engage with us and as the session goes on. So I would like to invite to the panel our panelists. We have Professor Gaurav Raheja. Okay, yes, okay. We have Professor Gaurav Raheja. We have Ms. Gita Balakrishnan and Ms. Roma Bhagat and as well, and Dr. Satendra Singh. If you could just come join us, we'll start shortly. And the co-moderators for this session will be Shreya Tripathi, who is Senior Resident Fellow at JALDI, and Ms. Brinda Shastri, who is an independent urban design expert, both of whom are also co-authors on this panel. And we hope you find this panel engaging as well.
Yeah, correct.
Okay.
Good afternoon, everyone. This morning, we heard a lot from the various Chief Justices and other lawyers who gave us a lot of input on their accomplishments and how they had managed to incorporate a lot of design ideas within the court complexes and the opportunities that they had to change policy and implement some of these ideas. So I would like to mention that our handbook that we have put together is something that has addressed a lot of these, and we have actually put out certain design ideas with floor plans and details and photographs that actually illustrate how these can be done differently or can be adapted to different types of court situations. And it's also to take into consideration the the idea of being inclusive, and not just for persons with disabilities, but also people who are vulnerable, as well as women, other genders. So we have covered the whole gamut of different user groups who are able to kind of use these court complexes. So with that, I would like to kind of start on introducing this particular session. So generally, we all know that architectural form and space of court complexes symbolically and physically express a vision of justice in society. In today's pluralistic society, inclusivity is an essential component that needs to be considered in the design of court complexes. So in this particular panel, which is titled Ensuring Universal Accessible Courts for All, Universally Accessible Courts for All, we will specifically discuss the reasons behind the lack of facilities for persons with disabilities in public spaces, such as the court complexes. And we will also delve into the need for a multidisciplinary approach to the design process. We will also touch upon the need for capacity building initiatives to be undertaken to change the mindset of decision makers. This was something that Justice Shakhtar brought up this morning about changing mindset and how to make these court complexes more accessible through that change in mindset. So the session will throw light on the manner in which disability is viewed and the conversations that need to be undertaken or initiated to change the perception and ensure universal accessibility for all. So I'll hand it to Shreya to introduce the panelists.
Thank you so much, ma'am. We are very lucky to have with us a very diverse panel today. We have Dr. Gaurav Raheja. Professor Raheja is a professor and head of the Architecture and Planning Department at IIT Roorkee. with more than a decade of teaching and research experience. He is a well-known universal design and accessibility consultant who has worked with the Government of India under the Accessible India campaign for the Prime Minister's office, the New Delhi railway station, and the Indira Gandhi International Airport in New Delhi. He is also a recipient of the MAFIS Universal Design Award, which is conferred by NCPDP India in 2010 for his professional design and research contributions in the domain of accessibility for persons with disabilities, among several other awards. We also have Ms. Gita Balakrishnan. She is the founder of Ethos, an initiative to bridge the gap between the students and professionals from the architecture, construction, and design fraternity, which has now completed 22 years. She also launched the ACEDGE, an online learning platform in 2018, which aids outside classroom learning by offering online education modules in the field of architecture, construction, engineering, and design. She is also currently undertaking a campaign walk for our cause. She has embarked on a 1,700-kilometer journey on foot through 7 Indian states over 70 days to bring focus on the architecture and design community, their contributions to society, issues, and issues that they aim to address through design. We also have advocate Roma Bhagat. Ms. Bhagat has worked for over 40 years as a legal professional in various areas of law. Her work in the disability sector has encompassed legal aid litigation, training, and capacity building of all stakeholders, advocacy, and policy work. She has been a part of 2 working groups under the 11th and 12th Planning Commission. It's working now, right? Yeah. She has also conducted training programs for the Vulnerable Witness program of Delhi High Court and the Delhi Judicial Academy, and has been the legal trustee for the Special Olympics. She has further been recognized as a trainer for the National Trust for Persons with Autism, Cerebral Palsy, Mental Retardation, and Multiple Disabilities, and the Rehabilitation Council of India. She was the point person for the National Human Rights Commission in organizing a judicial colloquium on disability for 52 High Court judges across the country. We also have Dr. Satendra Singh. He's a director professor of physiology and the co-founder of the Health Humanities Group at the University College of Medical Sciences in Delhi. He has successfully initiated numerous policies, including the integration of disability rights as disability competency in the new medical curriculum in India. He's a member of the core group on disability at the NHRC, advisor to the Delhi Disability Commissioner, and deputy editor-in-chief of the Research and Humanities in Medical Education Journal. He's the first Indian to be awarded the prestigious Henry Vicardi Achievement Award in the US, which is given by the Vicardi Center to leaders for their extraordinary work in global disability sector. We are delighted to have such a diverse panel to help us further understand the true essence of accessibility, accessible spaces generally, and courts in particular. We are going to discuss, as ma'am mentioned, some of the strategies that we may also use to achieve this motto of sorts that we have set out in front of us. I'll just quickly jump into the questions that we have for you guys. To start off with, my question is for Professor Gaurav Raheja. Sir, how do you think we can go about building public spaces, and especially court complexes, that are truly accessible to all, including persons with disabilities? And again, another thing that just has come up while the discussion has happened today, there have been many definitions and terminologies for the term disability that has been used. That some have said handicapped, some have said differently abled, etc. And as we know, currently the term we have been using is persons with disabilities. So what is your thought on that as well, sir?
So first of all, thank you, Shreya, thank you, Team Vidhi, and thanks to everyone who has joined us here online, offline, to make this discourse, I hope, carry forward from JALDI to a slower sinking pace of human evolution. Because both JALDI is the need, but slow and surety is the affirmation that also is the need. And both need their own time. So Shreya has put me onto two critical questions, and please allow me to be little out of the box with all due respect to the honorable courts, judgments, justice, because I think I'm still that, I wish to wear that creative child out of the box, and who feels offended when I see any document uh, which does not feel like to be read. And the whole dimension of law, legal access is about that. And I'm tweaking this before I answer this in a different way, because the whole question of defining access, as our previous speakers were using the term disabled, non-disabled, I think I'm still trying to come to terms with a term called non-disabled. Who is non-disabled, right? If today you give me a mathematical equation, I may not be able to solve it, right? Will that be a proof of my ability or disability? Many of us who in this room wear spectacles have able bodies, able minds, everything is able, but they know that there is something wrong which is visible to the outside world. Plus, the very acceptance of the fact in this sphere of disability is that so much of it, as an iceberg, is invisible. And this realization, actually, I don't wish to contest the word disability, but I think we've spent enough 2100 years of human evolution, so to say, to realize that human is like this. Life is like this. Why will we continue to discuss labels, right? And therefore, I wish to start with further simplifying this. If I put them in a sequential order, and that's what I did just here with a play of few words, that what is the chronology and the structuring to arrive at justice? And 4 words that I pick from this whole conversation is, first is the law. If there is no law, we wouldn't be talking about this in this room. So what is law? To me is legal access to wisdom, right? Where does the law get practiced? Though I believe there is a law of nature, then there is a law of nation, and then there is a law of conscience. And all these 3 become a part of conflict, consensus, or creativity in a courtroom. So what is the court then? Then to me, the court would mean a collective opportunity for a universal realization of our transformation. Because through every conflict realization or resolution, we wish to transform and send a message that no, we don't accept this, or we accept this. And so far our struggle continues is because I'm going for this battle a little outside the courtroom, because inside the courtroom is only a glimpse of India that we see. The real law is for enforcement in the real world. I am an individual in a home, a passerby in the street, a worker and an employee in somewhere else, and it's because something unsettled happens in my life there that I reach to the courtroom. So the very existence of court might not have been there had there been no conflicts. So the very idea is that how can conflicts be reduced such that the court becomes more accessible? And in that light, therefore, the third thing that the conversation mentions is the word ensure. So I find the answers within the word itself. Just ensure. I would say, let's ensure. You want to ensure justice? Okay, so I tell you, how do you ensure justice? I think if the E of the empathy cannot be part of any system, I don't think justice can ever prevail. Right? And empathy cannot be taught, while it can always be learned. So I would say to ensure is, everything is a verb. Empathize. The N is to nurture an environment in which both the conflict and the resolution can come together. Difference of opinion in the society is the foundation of any democratic process. But with difference of opinion, how we become so fundamentally against that the law of nature begins to suffer on the law of land. And therefore, nurturance is another critical dimension in which the way we design our environments, I think, plays a critical role. The third is the S, which is the S of sensitization. I do not know what bachelor's in law as a course content contains. I'm sure many qualified people would know that better. But I think today's education has immense knowledge and has possibly 10 times more information. But what the current experiences tell us is, in the age of digitization and artificial intelligence, I think I read a very strong statement somewhere that before we adopt artificial intelligence, can we do something about natural stupidity? So my question there is, because naturally we were sensitive, but artificially we are becoming intelligent. And that's a conscious call. So when people say, what are you working on? I tell them I'm working for a world which will come after AI, which is sensitize humans, right? The U is the celebration of universality, no distinction between the human and the ant, and the ant and the elephant. Let everybody do their job. And that universal coexistence does not use the word disability or any form of discrimination. It rather builds a discourse for the ant and the elephant to come together. And that's the opportunity the court provides under a legally available wisdom, right? That's what the law is trying to do. And in the environment that we call court, through ensuring, which means we said empathize, nurture, sensitize, universalize, and the R is to resolve. Finally, to reach to an E, which is empower. So if we can ensure, we can hopefully reach to justice, which to me is justifying universal sensitivities through inclusion of citizen empowerment, right? So in that perspective, if I were to put this whole thing together, re-terminologizing further the idea of disability, I think is not really the need now. We have enough of it. But it's the realization that even I am that. So far, because the whole discourse changes as long as I can continue to do this discourse by saying it is for them. So I always try and sit on the higher chair. I think the first acceptance is, no, my God, I realize 1 million disabilities despite which I sit on this stage. I acknowledge that. And I thank the good Lord above who still gave me the opportunity to be accessible to many others. And so it's my responsibility. So I think the discourse on disability need not be about the terminologies, but yes, the role of terminology is very important and critical, because this interchangeable use of the term disability, handicap, and so on and so forth. I have millions of examples collected, not just from India, across the world, where it changes the whole character of what we are doing. I was recently there in some place, it says disabled friendly toilet, green wheelchair symbol, and it was a step up. I said, no, what do I do? So it's a common apathy, and it only requires sensitization. We have got tired of commenting on it, but we therefore feel, let's come together, resolve it. It's not a war, it's a collective effort. So that is one dimension. The second is about creating this whole court as an environment. So I just want to pitch in here. This book is the first beautiful attempt. I want to use the word beauty, right? Let me call the ABC of the courts. One is the access, and the B is bold and beautiful. whatever the courts do, it has to be bold, but also should be beautiful, because beautiful things carry forward in life. And the C is the collectiveness of the court. And that's how the ABC of the courts can continue to make the world more accessible and build the sea of confidence in us that yes, and for doing that, why I appreciate this beautiful booklet is that it is a document which you want to read. Once when we authored one of those harmonized guidelines involving, I should place on record thanks to Shreya Shetty, Bhagya from Studio Ocker 369, that the whole idea of writing these standards and codal books was that make them such, and I remember when we showed it to some people, they said, "Oh, can I have a copy?" I said, "Are you would like to have a copy?" They said, "Why not? It's about us, right?" What I'm trying to say is, why can't such documents become coffee table books? Because unless they become coffee table books, the common citizen would never know. Just as today we are expecting the lawyers and the judges to do the audits of the courts, which is a civic infrastructure, likewise, citizen is also expected to read the law by themselves, interpreted by themselves. So I would say, can the legal books be also made that friendly? That's the call of the day. Can there be visual versions of them? Can there be anecdotal versions of them? Can there be simplified guidebooks? Or do they have to always sound as complex as the Resnick Hallidays and the Rodovs of physics, which without a diagram explain the complex physics, making it more complex for you? So because law is in action every day, even if I'm breathing, I have to ask, where is my right to oxygen? Under the shadows of my real estate apartments, I raise this question, where is the access to sunlight for my child? Because he or she has to grow in the shadows of the another tower. And is it not a constitutional violation? It is. So having said this, the first is the access to the document. The second, I feel, because any court, any building, any system that you look at, three very fundamental critical things come to our mind to make it accessible is, one is information, which I think this document is a beginning, but a lot more goes forward. Second is the infrastructure, which is ranging from court rooms to any other rooms. In fact, have seen in various courts a lot of nice tactile tiles laid out and lawyers' cars parked over them, right? Now, I'm ready to speak to them, but I know many conflicts happening between the lawyers saying that we are too many in number, there is no space. So somewhere, I don't know, but in a very polite way, can law be dealt with humility and less with arrogance? Is a shift in attitude, right? And I think most human right conversation will cease to exist if this attitudinal transformation happens by respecting the infrastructure that we have. And the third thing, which is most critical, I think, is the services, which is given by the humans as professionals. If you think the world, if we allow the AI to take over us, friends, thank you very much. Every day is a Sunday for us then, right? Who's going to the court of law? The AI is going to interpret. AI is going, and are you ready to accept that justice? The very fact, in fact, I have been trying to tell in all UI UX platforms also, the frustration today to book a cab and not being heard after 100 iterations of dialing certain call-free numbers, toll-free numbers, is there human assistance? Listening to machine voices has already sickened me. I don't know what's coming forth. So listening to a judge is the only hope that we have. And because we believe the hope of the H is human, not artificial. And that human opportunity of people's empowerment is the way we are looking at access. So that service is actually the hope, and that hopefulness will continue to be there as long as services continue to be staying accessible. Therefore, all this must start whichever way, but it needs to percolate to the level of services, because having a great court, nice infrastructure, nice information also will not serve the whole purpose unless the people who are at the helm of affairs to deliver those services be held on one side accountable, on the other side, this attitudinal transformation works happen. So I wouldn't wish to, go in a jaldi way, because sometimes jaldi can backfire in that context. But I want to go in a surest way, and I would give myself, say, a 10-year period, and then look at my 5-year plans on how these transformative actions can scale up and ensure percolation, so that, and this for which on one side is the action to begin in the courts, but I think a very strong action must begin in the schools of law where the new lawyers are being created. So I think with that, I would put my thoughts to rest.
I mean, we have also had a lot of these discussions. We used to do Wednesday discussions, and we have been having them for about 2 years now. It feels a little empty on Wednesdays nowadays. But yeah, this is definitely one thing that we consider, that in terms of, we can always give a book which has a bunch of directions, but there also needs to be an implementation policy, which is what we have tried to incorporate. Obviously, we cannot, prescribe as such, but we have tried to have that in place as well, so that if any court is to actually pick up this handbook and try to implement it, they also have that aspect of it covered. So we have definitely tried for that, and sensitization is actually one of the major things that we have mentioned there, because and as we are working with different courts as well, this is something we face again and again, sir. You're truly right. It's always doing it for them, not for us, which is why, like, a lot of facilities, I think in the previous session, they were also mentioning dioceses don't have ramps ever, because it's not considered that, they will be necessary. So that's also definitely something that we have tried to incorporate in the handbook. But talking about sensitization, I would ask this to Ms. Roma Bhagat. How can we, in terms of sensitization, how can we go about changing the mindset of the policymakers who are, like, making this decision at the top, and how do we get them to have this sense of empathy, which sir was also talking about? How can we go about developing that?
Am I audible? Yeah. That's a very difficult question. And before I go into the answer of that question, I'm just going to step back a little bit, and I'm just going to look at this whole process which has led us to be here in the first place, right? So what we're talking about is accessible courtrooms. So if I look at the range of stakeholders who go into making accessible courtrooms, it's the people who are going to be using it, which means the lawyers, the litigants, the court staff, the witnesses who come there, the service providers within the court complex, the judiciary. Yeah, so that's a huge range of people, right? The first question then would come to mind is to have we taken on board the first rights holders' view of what is missing in these court complexes? And does that then, working backwards, go into informing us when we make our TORs, whether for retrofitting or for going forward and building a new building? Because I'll just share with you that we went through this exercise for the Supreme Court. We prepared an accessibility report where we decided to have a questionnaire which was, to our minds, the absolute basic minimum that a court should possess in terms of accessibility. And we fanned it out to all the 39 benches of all the high courts across India. And the answers that we got back to that questionnaire, we've done a detailed analysis of it, actually threw up something very interesting, which was that despite the fact that there are so many, and people have talked about them in earlier panels, there are so many rules and regulations, etc. Some of the newer court buildings also do not have the infrastructure required to put a tick mark on every single question on our questionnaire. Now, this is what we consider the basic. I mean, this is our building block to say that this is not to say that we'll have perfectly accessible courts, This is to say that this is the building block for the first stage. Like if we cross this threshold, then we can look at more advanced integration of accessibility features. So the issue here is the first and foremost, we felt lack of standardization. There are like 200 different, so there is the court system, management system, there is the national building code, there is this and there's that, and there's so many things. But who is saying, all right, for every court in India, for every high court in India, this is what you must have as a basic infrastructure. So then it becomes personality driven. So if you have an empathic person who's at the spearhead or is at the helm of that particular court infrastructure, of course you'll have a better outcome. But then is that what we're looking at? So that's the first thing I have to say. The second thing I have to say is, and this again comes out of a personal experience of being invited as a guest faculty to do lectures for master's students in architecture. One of the critical stakeholders in providing accessibility in the built environment is our architects. But they don't know. So if they don't know, and I mean, I think it's an absolute crying shame. And because I took my entire class, I said, I'll explain accessibility to you visually. Please come down with me, and literally took them off their classroom down to the ground floor of the School of Planning and Architecture. And I cleared out the girls' toilet and I said, please, all of you come in and tell me what's wrong with this toilet. And then I took them into the disabled toilet. There wasn't even enough room for a turning radius for a wheelchair, which is why when we did our questionnaire, we categorically provided for measurements, because it's not enough to just say, like Sir just said, you say disabled friendly and then you have a step, and how does a person in a wheelchair navigate that step? So you're not thinking, right? You have so many different examples. I mean, I'm not going to go into it because I think we're, kind of in a time crunch, I feel. But yeah, so that's one part of it. But the second part of it also is, with the best intention in the world, you're only as good as the knowledge you possess. So you can't go beyond your scope of knowledge and understanding, right? So as again part of this process, when Justice Shakdar asked us, he said, I know that you're concentrating on the high courts, but I want to make Delhi into a model state as far as disability access is concerned. So please go into the district courts as well. And we did. And, when we met with the judiciary in the district courts, it was actually quite an eye-opener, because honestly speaking, what we realized was that, each one of these complexes has their own challenges. And with the best will in the world, they had absolutely no clue how to go about retrofitting a building. Now, if you don't know how are you going to make it accessible? A simple example, in Karkarduma, the courtroom is built on a split level, and the lifts actually open on a mezzanine level, where you have to go 6-7 steps down to access one floor, and then 6-7 steps up to access the other floor, and you're just sort of floating in midair. So they have made the ground floor accessible because that they could, visualize and do. But they said, how do we make the balance of the court accessible? Like, we have no idea what do we do with this situation, And so we suggested that, you can have pods which are placed on the outside, which can go up and actually open per floor and not follow the system of the lift and the mezzanine floor, just omit it altogether. So you find a sort of a... But the point I'm trying to make is that unless these decisions are looked at in a targeted manner, one shoe can't fit all. And that's something we know in the disability sector so clearly. And having said that, and having had the access to having practiced over a 40-year period in different courts across the country, and a lot of district courts at that, one thing I'm going to say, and it's going to be a little controversial, in my mind, the court complexes that I've come across in my career as a lawyer have been one of three kinds. Okay, the first kind has been the kinds which there's absolutely nothing you can do. There is just nothing you can do to make that. It's more cost intensive to retrofit that structure than to bomb it and recreate it. Yeah, so that's one. And the worst part of the whole story is that oftentimes a lot of these structures have been in spaces where there's enough space and to spare in terms of open grounds, where you can actually build a perfectly good structure and then demolish the existing one. So it's just a question of how you think about it. So that's the first lot. The second lot is where, it will be difficult to innovate, but not impossible. You would be able to innovate, but it would require a considerable effort and a dedicated team of people who would actually go in and say, right, this is what we can do, this is what we can't do, and this is how we need to do it, right? And then there is the third bunch, which is the bunch where it would be very easy and you actually feel very upset when you go into a situation like that to say, it could have been disabled friendly, dash it, with just a few small, alterations, amendments, etc. And then you take all of this put together, and then you have the problems that are created by the implementational aspect. So you'll have a perfectly decent entry into a courtroom with, huge double doors which can be accessed very comfortably by a wheelchair, and smack bang in front of it with a 1 foot sort of gap will be a line of cupboards. So we've all seen this, right? And then you will have some seating for the lawyers, then you'll have, maybe a chair for and a desk or 2 desks or 3 desks for the Naib court, etc. Now all the space is taken up. And I actually saw a disabled person who was in a kind of a hand cart, a floor level sort of hand cart, who could not bring that hand cart in. So he actually had to leave this hand cart outside the court and then come on all fours, which is not okay in any sense of the word, So there's that. So this is one part of it. And another part of it, I'm sorry, this question was not put to me, but I just want to sort of comment on it, because it's been a long-standing battle that I've been fighting. And that is that, we worry a lot about nomenclature. So when we talk about nomenclature, there are 2 kinds of nomenclature, I feel. One is that's actually offensive. So let's take the word handicap. The etymology of the word handicapped is somebody who has a cap in hand, which means is only capable of begging. Now that's a problematic word, and that definitely is a word that I would say has to be strenuously opposed. Having said that, whether you call someone disabled or you call them differently abled or you call them specially abled, special needs, challenged, doesn't matter. Why? Because these are words that are at a particular point in time, you suddenly feel you need to waste a lot of time and energy on new nomenclatures, whereas you should be actually concentrating on what you really need to do, which is to change the mindset that informs that particular nomenclature. And the worrying part is that this discussion just kind of spirals each time. I'm sorry, but I feel I have the right to say this because I also stand on this side of the fence. I have a physical disability. So, you know, luckily I can say these things with impunity. I can say कि अंधे को अंधा कहो तो कोई बुराई नहीं है, which is under normal circumstances problematic. The other difficulty I have is, so I think the word that you were looking for is, instead of disabled and non-disabled, the word is mainstream, right? So if we talk about mainstream, it's the mainstream that makes most of the decisions. And that actually, to me, is problematic, because when we talk about disability and we talk about the first rights holder, where is the first rights holder? Where do we see them? How are they there? How are they present? And unless conversations focus clearly on the first rights holder and the fact that they need, their lived experiences need to have a part to play in this entire gamut, you know, we are going to be in a lot of trouble, right? So I feel that I think if this disability discourse is to yield something positive, then one is the fact that we need to have something which is interdisciplinary. It's not just one aspect of it that we can take up and say, all right, so this is good enough and this is not. Also, I have one other another thing to say, and this is again coming out of my practical experience as a lawyer. Oftentimes we don't realize that leading up to the courts, there's a certain path that we need to follow, right? Sometimes that path that leads to the gate of the court, and I'm not talking of the physical access, but I'm talking about the navigation that you have to make, is not possible. So what do you do then? So for example, I had somebody who came to me who was in a big problem, and the reason they couldn't address that problem was because a part of that problem, and I said, I need this information in order for me to go to court for you, a part of that information that I required lay in a government office that was completely inaccessible. Now, that also is part of access to justice. So that's also something that needs to be factored in. And that needs to also be looked at in terms of how you promote access, you know. It's not just that you come to the court, at least for disabled persons who may not be able to access that information, there should be a provision that they can come to court and they can request for that information so that it comes to them or whatever. I mean, I'm just saying that, but it has to be built into the system. This is what we're talking about, access, you know. And the last point that I want to make is that even today, there is a huge lack of faith and belief in the disabled person. And that is in and of itself extremely problematic. And I saw this firsthand because I had two matters involving, one was a POXO matter where there was a 4-year-old child who had accused one of her family members of some inappropriate behavior. And the matter came to trial when this little girl was 7. And right through the entire trial, this girl, this 7-year-old, never opened her mouth. Not once. She did not reiterate anything. She just did not open her mouth. She was completely silent. And on the basis of her 164 statement, the person, this relative, was convicted. Now, the shift to another case where there was a 28-year-old a girl who was non-verbal, in a wheelchair, suffering from cerebral palsy, also had a rape charge that was brought against a family member, and the complaint had been lodged by her mother. Now, this girl actually went through a cross-examination in a vulnerable witness courtroom, and I was present. And, we had to mediate it through the judge because the opposing counsel was extremely offensive, and he was very hectoring, and he was really, really aggressive. So we had to mediate it through the judge. And luckily for me, this particular judge had been to one of my judicial trainings, and he'd actually sort of, gone through a bit of the process as I had explained it. Anyway, cut a long story short, this girl, we had everything in place. We did, as part of the cross-examination, before the cross-examination, in the chief, we established that she understood the difference between a truth and a lie. We explained that there was a nomenclature issue, so we categorically, clearly got her to, on a body part chart, point out what, body part she was referring to. We then affixed a nomenclature that she was comfortable with to it. All of this was done. And she gave absolutely clear testimony to the effect that this particular act had been perpetrated, right? Guess what? When the judgment came, the judgment was that the accused had been let off. And so I said, but why and how? They said, oh, the mother's testimony, the mother who brought her to court, the mother's testimony was not okay, And I said, but the girl herself, the first rights holder, categorically said that this happened. Why would you disbelieve her? Number one. Number two, in any event, the mother clearly was a victim of abuse for a period of 25 years. Or 25 years. That victim of abuse, you can ask them what happened, and they will tell you what happened. They will not tell you why it happened. They'll not tell you how it happened. But those whys and those hows are very important to inform. I'm just saying that the difficulty here is that disabled persons, even today, are not believed. And that actual lack of belief transforms into what is seen as their quote-unquote voice when it comes to designing spaces for them, when it comes to looking at workable spaces for them. And as you very rightly said, it then becomes us and them. And it becomes also a kind of a privilege, It's like not viewed as a right. Why? It's my right to be able to access something, and if you're not giving it to me, then you're the bad guy. I don't have to be given this as some sort of a present or a charity or something, so that the whole conversation actually is completely standing on its head, So, I think I've taken up too much time.
No, actually, there are a few things that I picked up from what you just said, which was really useful in terms of like when we consider the design of buildings, and you talked about the terms of reference, the TORs that we create for the buildings, as well as certain standards that are necessary in terms of like, there needs to be a ramp, there needs to and there is a certain slope for those ramps. So our handbook has actually taken into consideration some of these, what we are calling almost like non-negotiable principles that need to be followed, as well as certain minimum standards. It's not even minimum, it's the non-negotiable standards that need to be followed to make sure that these places are accessible. So, Yeah, and coming to the point of, access to the site itself where the court building is located, we have also considered the externalities, the security features, the walkability of, accessing the site from the outside, mode of transport that you can actually access these court complexes with. All of these have been actually somehow addressed in the principles that we have brought out. And then coming to the training sessions you mentioned, I have a question for Dr. Satendra Singh. As a person who has initiated several policy reforms to integrate disability rights, what do you think, or how do you think we can ensure that the court staff and other users are adequately trained and sensitized, and that, quite often court complexes do provide, or other public buildings do provide some of these facilities that we keep mentioning, like, in terms of a ramp or accessible lift services, and also certain staircases and pathways that are accessible. But oftentimes, it is not necessarily used by the people for whom it is meant, and it is adapted or adopted by others for some other things. Like, for example, Dr. Raheja was mentioning that tactile paving exists, but then we start using it for some other purpose and we start parking cars on top of it. So when we have to sensitize people, how does it, in your experience, what is your perspective on, that?
Thank you so much, Brindaji. Taking a cue from Justice Gita Mittal to bring on the inclusivity. Julie, everyone, and I'm a middle-aged person with black hairs wearing a blue shirt which is collarless. In 2001, the famous Stephen Hawking decided to visit India. He came to Delhi and then he expressed his desire. He wants to visit Qutub Minar and Lal Killa. Now that opened a Pandora's box. 2001 it was, because none of these are accessible. In just one night, Ministry of Tourism, Archaeological Society of India, and the Ministry of Social Justice and Empowerment made wooden ramps overnight for a visitor who is not from India. Fast forward to 2015. What are the facilities existing for litigants with disabilities, judges with disabilities, lawyers with disabilities? In 2015, the very first meeting of the Accessible India campaign, I was there and I said to the Joint Secretary, this is like a dream come true. Fast forward to 2023, 24 rather, Amrit Kal. I'll give you an example of 3 buildings inaugurated by no less than the Prime Minister of India, who actually started the Accessible India campaign. The Parliament of India, the new Parliament rather, the Temple of Democracy. Is it accessible? It is not accessible. The Ram Mandir Ayodhya Temple, there was so much talk about that. Is it accessible? It is not accessible. The Pravasi Bhavan of the Ministry of External Affairs, inaugurated by the Prime Minister of India, a very fancy, beautiful building, aesthetics, all good. Is it accessible? The answer is no. I have visited that building. So what I'm trying to say is that in the previous session, with all due respect to the panelist, very high power-packed panelist, in the end there was a question that there is one more panel. Do we have to attend that? The other words, a person said that, no, it is not for us. I am not from the judicial background. I am a medical doctor. And I want to tell you why it is important to hear the experiences of litigants with disabilities. I have visited CAT in Accessible. I was called as an expert medical doctor and a witness at the Juvenile Justice Court. Accessible, not accessible. I went to Delhi High Court also, not accessible. I tried legal aid also because it is a free of cost aid to people with disabilities. I went to the Patiala High Court and the main, their office of DSLSA is on first floor with no lifts. That was 8 years ago. If you go back today, just next to the India Gate is your Patiala House Court, and from periphery you can see that there is a huge banner which says that reserved for people with disabilities. It is never reserved, it is always parked with vehicles and other stuff. My question is why it is important for the judiciary to know is that very clearly section 44(1) says that no new building shall be given permission if it does not adhere to the accessibility laws. Section 40 में clear cut बोल दिया गया है which guidelines to follow. Now there is no ambiguity कि आपको National Building Law Board follow करना है, Chief Commissioner की guidelines follow करनी है. It is very clearly written there. Section 44(2) says that no completion certificate shall be given. Why the new parliament building was given the completion certificate? Why the Ayodhya temple was given new completion certificate? Section 45(1), Professor Raheja, with due respect, said, I would follow a slow and steady path. I, as a person with disability, says there is a JALDI. For how long we should wait? Section 45(1) says that 14th June 2020 was the deadline for all services to become disabled friendly. And 14th June 2022 was the last date, rather the deadline for making all public places accessible in Incredible India. We are now in Amrit Kaal. Can we see places accessible? Can we see district courts accessible? Now section 45(2) also says that even if your buildings are not accessible, you have to on your website very prominently put down the action plan. How would you like to make that building accessible? How many district courts, high courts in India have that action plan on their website as per section 45(2) of the RPD Act? As you said, ma'am, what needs to be done? So some of you said that they would like to know how the new lawyers are learning about the RPD Act. I was called at the National Law University of New Delhi. I was there for a talk, and a blind student, a student of law, stood up and said, sir, what you are saying is like music to my ears, but nobody talks about RPD Act or the other 3 acts which are there in the disabilities, because it is not a mandatory learning in the law course. How would they know about that? I went to a Samadhan building where the vice chancellor of a very prominent national law university is there. There were 8 steps and I was called to meet with him. This is in 2024. The solution, I am a medical doctor, but the word universal design has been now included in the new medical curriculum, so that future doctors know what the meaning of universal design is. But do the future judges, future architects, or the future lawyers know about that? In my RTI to Architectural Council of India, they said it is not a mandatory assessment part in the curriculum. Something which is not assessed, which will be never be learned by the students. In 2017, the Mental Health Care Act came, and within the same year, there was a case in Delhi High Court, where the Delhi High Court, they were very hard-hitting, and they said that action should be taken on the police officer, the psychiatrist, and the Metropolitan Judge of Rohini Court, who ordered a senior citizen, who ordered that he should be taken to a psychiatric hospital and should be evaluated. And they ordered the Delhi Judicial Academy 4 orientation courses for all of these people. Now the same thing is already there in the RPD Act. If we care to read about that, 47(1)(a) says that there has to be a mandatory disability rights training of legislators, judges, and lawyers. That is, I think, the first step where they should know that there is a mandatory reading. The second thing is why no punishment ever has been taken right now. Why the buildings are being inaugurated. Why our so-called VVIP people who inaugurate these buildings never follow a ramped pathway access. They will realize that the buildings are not accessible. So I think these are the few things. And also, I think if you talk about terminology, I will not go into the terminology, but having said that, in the Mumbai High Court, Justice Patel, in one of his judgments, he came very hardly on the National Trust Act, which uses the quote-unquote the word mental retardation, and he said that if anybody used this word in my court, it will come at a cost. But then in the very same sentence, he scored a self-ball, that which retard person framed this National Trust Act. And I think that's why one of the positive thing is the new Supreme Court guidelines on disability which are there. I think that should set the state forward. But having said that, it is very important when the decisions are being taken. For example, the accessibility committee, it is very heartening to see the representation of people with disabilities in those committees. Until and unless these things happen, we will keep on talking about beauty, aesthetics, and nobody will talk about why we need this JALDI. I want to see India accessible, and in this lifetime, not in future lifetimes. Thank you.
Ma'am, my question is to you now. Basically, we have been speaking about this, that a lot of times there are provisions that are being made, but they are clearly not well made. Like ma'am mentioned, and also sir also mentioned, that there are provisions. There will be a ramp, but it won't be at the right place, or the lift doesn't reach the right floor, etc. So how can we, going forward, ensure that accessibility is a part of the initial design process and the design planning that happens rather than afterthought, as it appears to happen in a lot of places, including in ISC, actually, I must mention. And secondly, like, what are some of the ways in which the implementation authority, so, and that does not include only, say, the building committee, but also like the PWD that is involved, the workers they hire, etc., how they are also made aware of the provisions that is being put there and why is it necessary. So how can we go about doing that?
Thanks, Shreya, for the question and for having me here. Let me begin by saying that I think I am not really an expert on accessibility or universal design for that matter. I am an architect, and unfortunately, despite being an architect, I'm not an expert simply because it was never part of our curriculum. It still isn't mandatorily part of our curriculum, unfortunately. I'm glad it's part of the medical curriculum so far. And the last 3 days have been kind of interesting and a learning for me. I don't know how many of you know, I am known for my walk. She mentioned in passing, but I'm known for my walk from Kolkata to Delhi. I walked 1,700 kilometers for the cause of exploring design. And I walked from Chennai to Bangalore with specifically for universal design. This was earlier this year in January. On Tuesday, I fractured my leg. So it's a space that is very unfamiliar to me. And I have been in a boot and in a wheelchair. And I've seen places that, I've been fortunate to see places that some of you haven't seen. I came with her this morning. She was accompanying me. I was in the wheelchair. There is a ramp to this place. And I saw the kitchen. I saw the service entry. I saw the service lift, which didn't work. And I don't think any of you got to see any of that, right? So fortunate in that sense. But, I mean, it's in pun, but I'm saying, we also need to, while you're ticking off these boxes and saying there is a ramp, where is the dignity for the person who's using the ramp? I also have, you talked about aesthetics a little while ago, about how important it is for designers and architects. And I was at the India Habitat Center yesterday. And it's like right up there for us architects. It's like a case study for almost anything and everything. And the only way that someone in a situation like mine could navigate all those courtyards, I mean, that's something I can never experience, I presume, because there are steps all over the plazas are all over the place. But I can only use the basement to access the different blocks and get into. And I was waiting in the basement for half an hour because none of the cabs would actually come down there, and finally I had to flag one private vehicle to request him to drop me at the gate so that I could get into an Ola or a cab. So much for our, and I've also heard of, I mean, I'm not going to take names, but I've heard of corporates whose offices are designed by extremely powerful or well-known or well-appreciated architects, and they've asked me why, these corporates have asked me, why is this whole thing of form and appearance so important for an architect when basic functions are not being, and this was a firm that believes very strongly on universal design, and it's part of their CSR. And they were not able to make this building of theirs a model for universal design, which is what they would have liked it to be. So yes, so I think we as designers have a hard road ahead, and it begins with, you were talking about mandates, it begins with making the study of universal design mandatory in our curriculum. We've done a small course, in fact, with Shreya Shetty being involved in the creating of the curriculum for colleges and schools, and we're opening it out to, and Dr. Raheja has been part of that as well. And we're opening it out to everybody freely, and we're going to add modules to it. So I think, when you look at any court complex, again, who designs, I mean, who's responsible for executing that project, it largely comes under the purview of the government, I'm presuming. And hence, the target audience actually to sensitize and to make aware is those in charge of taking those important decisions at the fundamental level. So how do you get that intent right? That this is what this building needs to be to start with. And then how do you get to the design and planning? Because these are points that came up in the morning discussion. So then you talk about design and planning, then you talk about budgets, because that's the gap between the talk and the walk, actually, I guess. The execution, the maintenance, and the use. So I think it may be, I mean, it's good we are talking about courts here, and I think those in law probably wield the highest power to be able to probably get that intent right in the first place. You're going to be able to influence the ministries and say that this is what we need to do. So I think that is something that's possible. I think it's very important. We talked about a lot of training sessions. So capacity building and training at all these levels, whether it is the decision makers, yes, they need to be also going through some kind of training to get these decisions right. And then those who are actually at the designing level, whether it's architects, whether it is the engineers, whether it is, we talked about it needing a lot of people. We need psychologists, we need accessibility experts, we need contractors. So all of them going through some kind of training at different stages, right from conceptualization to the actual execution and even after, including the users. And you know, we are talking about materials, we're talking about, and I think there is no repository just now for anybody, even with the right intent, to be able to, you know, take this from beginning. I know how much Shreya struggled to get that place, the villa, ready in Bangalore. So even products that you need, the finishes that you need, the electrical fixtures that, or the technology that you may need, and so on. And I think the key here, I think, is awareness. And I believe from the space I come from and what I have done in the last 22 years of my life, in the recent 22 years of my life, is creativity in you know, making that awareness happen. You've got this handbook as the first step. You're talking about implementation, but I'm talking about dissemination. How do you even get someone to say, I want that book? You talked about someone saying, there are very few of those people who will say, I want that book. So how do you make people, one, know that there is a book like this, and two, make it easy for them to even comprehend what's there? So you might need to look at visual tools, aids, graphics, breaking it down into modules, into videos that people can easily access. I also think it's important to gamify the content. Very important to gamify the content. It might seem trivial and small when I'm saying this, but if you want it to reach and make that impact and make people want to aspire, a competition between the different courtrooms in a court, saying, and budgets are constrained, I understand, so saying nobody gets a budget. You have what you have, and let's see how you can make it most accessible, is something that might make people more aware and make them want to, you know, I think every time there is something like that, even you know, you talk about Swachh Bharat. Why does a particular city work harder to keep its city clean, and why doesn't somebody? So maybe having that, and not just in the space of courts. If we could look at, we have a rating system for sustainability. If you could actually get a lobby in place for a rating system for, I'm not even saying universal design, for design, where sustainability, accessibility, everything has their points. I think many of these architects who kind of shy away from some of this will toe the line, because it's giving them that visibility. It's marketing, but I think it's essential. And I think that's something that we need to do. So yeah, changing mindsets in all different ways possible, capacity building. We talked about training programs. I'm talking about having, you know, you have these little boards outside a toilet, how did I perform? You know, so having that also in some way, you know, saying which courtroom performed the best across a city, courtroom in a court or a court in a city performed the best from the user's perspective. And like many people have said, how do you get the users on board? How do you understand from them what exactly is essential and what is required? I think we'll be halfway home if we get some of that in place.
Actually, I had another small question for you. Since you've been actively working with design professionals and students and trying to get them to become conscious of these factors that we have been talking about today, how do you think that we can advocate for increased funding and resources to get these implemented? It's an advocacy question.
It's a hard question, but I think it comes back to marketing. Why is a builder willing to put in money for that rating system today? Maybe 20 years ago, he or she wouldn't have been. Wouldn't even look at it. It'd say, nahi yaar, no way am I going to spend on products that are so much more expensive, because I'm just selling the flat apartment and going, right? But the minute there is that visibility that person's going to get, I think you will probably solve that problem. So I think marketing universal design and marketing design, which is what I probably tried doing through my walk. I'm shamelessly saying that here. I put myself out on show and told my community of designers that we aren't relevant to any other stakeholder if we don't do things right, if we don't interact with the community for whom you're designing. And I think that became a turning point in also when we talk of the different layers, again I'm deviating from courts and I'm talking about general, because I think everybody here agrees that if there is general empathy and general awareness, this problem will also get solved. So if you look at how many of our buildings are formally designed by architects, very few. Maybe the big ones that need permissions, but 80% of them probably are built just with a contractor or I think, again, running training programs, we have a wing called Shrama through what I do with my foundation. I think running training programs for even the construction workers, because in many cases, they are the contractors. They are actually doing that little design and saying, bana dete hain. So if they are also told how important this is, they're exposed through simple flashcards and presentations, I think we'll have some of those buildings that are not designed formally also complying.
Sorry, can I just say something very quickly? This is some time ago, there was this Jawaharlal Urban Renewal Mission that was there. This was around the time when the first Asia Pacific conference on homeless and housing happened. And we were talking a lot about how we can, make housing, EWS housing was the word, more accessible, etc. And it was actually amazing to me that nobody realized that the laws were in complete conflict with each other. The kind of provisioning that was done in one was actually destructive of the other. So where you were saying that, a disabled toilet needs to be this big, you need to have an X number of toilets for an X number of dwelling units or families or whatever. The other part of this, so what I'm just trying to say is that when something like this happens, and this happens consistently, and particularly even here, and I mentioned this earlier also, we talked about a lot of, different guidelines that have been issued over a period of time in different diverse ways. What happens is, without realizing it or recognizing it, sometimes they can be at conflict, but even if they're not, some of them can be less and some can be more, and then people can choose to pick the one, so it's like cherry picking. So I think somewhere we also need to really look at establishing a kind of standardization and trying to prevent this plurality that happens, where you know, in thing A, you will say X, and then thing Y, you will cut it down and say something quite different. So somebody else can go to that law and pick it up. You know, it's not a very pleasant way for functioning.
Thank you. I think it's quite evident from the discussion we have had so far that there is there is the sensitization and the empowerment that needs to happen from the bottom up in terms of the user groups that are using our code complexes. And on the other hand, there is also this top-down approach that is necessary from the judiciary to implement some of these things and find means and ways to do this. So I think that would possibly summarize what we have been discussing today. Maybe right now we can open it up for any questions you might have to any panelists, or I don't know if we have time for this.
So I think we'll have to.
No, you can continue.
Of course. We'll just quickly then take a picture of the panel.
Sure.
And
I'm
then
sorry,
we
I
can
have a
jump
flight
into-
to take, so I was expecting this to get over a little earlier. So, yeah. You can take a picture and I can get up to you.
You need to stand.
You can come closer. Thanks. Thanks, thank you.
One round of questions.
In case we have any questions right now. Okay, no. Then I think we can wrap up with the session.
I just wanted to say we've also had people joining us online, and especially thanks to Mr. Dipankar, who has brought up a couple of really good points while the discussion is ongoing, specifically highlighting the need for awareness. In general, awareness with regard to codes, how can we ensure we have disability committees and accessibility committees taking up awareness at a larger scale, and specifically how do you ensure that the measures that are currently being taken are also disseminated so that people who use these facilities are actually made aware of them. So I just, okay, I'm almost done. But I just wanted to highlight this because I thought this was a point that was very crucial and has been brought up in the chat but hasn't really been communicated everywhere here. But something for all of us to keep in mind as a comment to think about. Whatever steps we take,
If people have any thoughts about that, that will be very helpful to hear in terms of what I can take back to the accessibility committee, at least in Delhi. If the panelists have any thoughts about that, it will be very helpful on both those aspects, like number one, sort of awareness generation efforts which accessibility committees might take up, and then dissemination. Dissemination is very important because we find that there are several initiatives, like Justice Mittal spoke about the sign language interpreter one, that it was already there and no one knew about it.
If I can respond very quickly to that, I think there is a very important committee in the RPD Act, which is the district level committee. In fact, the Seema Bhagat case, not Seema Bhagat, it was Seema Girjalal in the Supreme Court case, which was on the same issue. Now, every district must have this district level committee, and which also include organizations of persons with disabilities. I think this is a body which is mandated by the law, and they should work in tandem with the DLSLA or the Delhi Judicial Academy, so that they can do this, awareness workshops together. Because this committee has members of people with disabilities, and this is the way in which the message will go to the community within the districts regarding the awareness sessions and all that. So that is one, insight from my side.
Okay, I think.
The DM is the chairperson of this committee.
Okay, so I just want to ask any of the suggestions on the monitoring and evaluation once the infrastructure is built. So how do we maintain that, and how can we enforce that through laws?
I have had always big fights with the public works department people whenever I have a meeting with them, because they come up with new budgets for creating new things, right? Now, my one thing is that the court should strict heavy penalties on any retrofitting cost, because now we have for section 45(2) completion certificate, and no building should be considered if it does not follow the accessibility rules. Still they are creating those buildings, so all cost of retrofitting should be levied on the executive engineers who are responsible for that. If there is one such case, one such example from the court, things will fall into place. सिर्फ डंडा ही काम चलता है हिंदुस्तान में.
If I can add to this, I think one of the keystones in this whole arch is the people who are providing these certificates. And what is their knowledge level, what is their awareness level, and what is their implementation level. तो जब चेक करने वाला इंस्पेक्टर ही इस बात को नहीं जानता है अच्छे से, तो सबसे पहला प्रॉब्लम तो वहीं आता है. सो जहाँ पे आप मेंटेनेंस या ऑक्यूपेंसी या क्वालिटी चेक को कहीं एश्योरेंस की बात करेंगे, I think this question should be raised that one is, till when can we have such people passing over buildings who are not competent to qualify and say this to a certain thing. Second thing is in the protocols, the SOP. Is there an SOP for granting an occupancy certificate with quality certification? And this, I would say, in public domain, not just for the courts. I have been raising this issue many times, even in the world of real estate. For a 500 rupee product on Amazon, you get two things almost free. One is 7-day return back period and a warranty. For a 75 lakh rupee, 1 crore rupee worth infrastructure, you get none of this. No trial and use. You have to accept what we have given, and no warranty. It can leak the very day you do Graha Pravesh. Right? No, it is because this is a very serious matter in terms of we are on one side talking about finance and budget. On the other side, we are not accountable for a crore rupees. And this can absolutely change, though I am not a lawyer, but I think I am coming from a public perspective here. The public can ask for a law. जब 500 रुपए के लिए हम कंज्यूमर कोर्ट में जा सकते हैं, तो मेरा बिल्डिंग की लाइफ मेरे लाइफ टाइम से भी ज़्यादा है, तो उसकी क्वालिटी के लिए क्यों नहीं मैं जा सकता? And this can only be empowered by law. As you know, the RERA Act came into place after many such violations happened. We had a recent case in judgment when 2 big towers in Noida were dumped to the ground. Many other cases still lying in the courts. And real estate is a big infrastructure sector, and I keep asking the question, what is so real in it? Right? So because this is where the fundamental comes, is where you talk about maintenance. Maintenance is directly proportional to what kind of quality has been invested in. And if quality cannot be ascertained and checked and given to me as a quality certification, मेरे पास हर घर में ये होना चाहिए इसमें क्या लगा है, and somebody is responsible who I can go back to is a warranty clause. And if these clauses can be raised, I think by the legal bodies, we as civic citizens can talk about it. If we can bring in that kind of a law, and second, as agreed with Dr. Satendra here, I think the E, which I think I missed at that point, is the enforcement. I think we are still shying. The E of enforcement, whether it is punitive, whether it is whatever, I think as long as we continue to shy with this, definitely we are creating inaccessibility every day. जब तक उसके लिए सही में एक कठोर एक्शन लेना पड़ेगा, it's a daily thing. And on top of that, I continue to say, जिसकी ज़िंदगी में एक्सेस रोज़ चाहिए, उसको एक भी दिन अगर आपने नहीं दिया, it's a complete violation of a constitution that you have denied access to life. So if justice delayed is justice denied, then I would say access delayed is life denied. And that's absolutely criminal, even without any criminal proceedings.
Thank you, sir.
Thank you.
I think with that we'll wrap the session. I will just invite Priyamvada to come give the vote of thanks.
we also did have someone online who wanted to ask a question, but in the interest of time, since we can't continue, but I just want to reiterate again, please take this opportunity to continue to keep in touch with us. Our website, as we said, has a means of communication where we can take this conversation forward, which is extremely critical. And before we wrap up, I just want to take a couple of minutes to thank everyone without whom this report and this event would not have been possible. And first, the authors, because as we've mentioned over and over again, this has been a lot of cooks in the kitchen, but we feel that the result could potentially be worth something. And so Shreya and I want to express our gratitude to Brinda ma'am, who's here today, and to Shreya Shetty and to Bhagya Madhapur, who unfortunately couldn't be here due to a last-minute infrastructural problem at the Delhi airport. But and also to our other co-authors, to Abu Bakr Sheikh and Gayatri Ganesh for drawing the floor plans that you will find in this report, and to Akshita Hariharan for the illustrations, and to Rama Raghavan, who came in at the very last minute to help us make this book as beautiful and bold as it currently looks. And also to Milind at BNA Technology Consulting Limited and Arun at HMPL Consulting Limited, who gave us insights on IT, security, and acoustics. And multiple Vidhi interns as well over the course of the last couple of years for research assistants, and as Deepika mentioned earlier, to Kunal Agnihotri for designing the video that we played here today. And we also have to mention that the report owes a great deal to our peer reviewers, Ms. Damini Ghosh, and to Mr. Sanjay Kanvinde, who is here today. Thank you so much, sir, for coming. And your insights were really, really helpful to helping us make the final form of the report as comprehensive as it is. And we also held multiple consultations over the last few years with too many people to name, but quite a few of them have been in touch with us regularly in helping us refine the recommendations in the report, and that has been extremely crucial to have this interdisciplinary result that we have here now. And of course, for today, thanks so much to all of you, our lovely audience, for coming here and for staying here throughout this entire day. And specifically as well to our panelists, of course, for your time and for your crucial insights that you've given us. And this commitment that all of us share is really heartening, and we hope that, as we said, we continue to keep this conversation going. Today isn't the culmination of our efforts to do this design handbook, but it's the beginning of a longer, harder journey up ahead. And of course, last but not least, I must thank the staff at IIC for the venue, and the administrative staff at Vidhi for all of your help in the logistics and support. To Amit ji, to Ashish ji, and to everyone else as well for ensuring that the event ran as smoothly as it did today. So we look forward to taking this carrying this forward, but for now, lunch is available outside. So I think we've delayed lunch long enough. Let's all go and eat.
I want to add thanks to our sign language interpreters.
Yes, of course. Yes, of course. So sorry.
So
sorry I missed you out. Yes, absolutely. And to our volunteers as well for all of your support. Yes, absolutely. Thank you. Thank you all so much.